Yes, Mr. Cohen.
My lords, my lady, I appear for the appellant, defendant below. Mr. Solomon KC and Mr. Halban appear for the respondent here.
Yes.
Claimant below. In terms of the identity of counsel below as compared with this court, all of the same counsel appeared on the consequentials hearing. On the hearing of the summary judgment application itself, Mr. Halban appeared alone for the claimant and Mr. Campbell of counsel for the defendant. There are 4 grounds of appeal. 3 of them overlap considerably. They concern the summary judgment application. And if I can put it in these pithy terms, what we say is that the judge was wrong to weigh and balance, but insofar as he was right to do that exercise, he got the weighing and balancing wrong. He just approached the factors in the wrong way and developed conclusions that he was not entitled to develop. And the 4th ground of appeal concerns what I've described as the time to pay application. We say the judge was wrong about that. This was a particularly difficult situation where 3 gentlemen have over the years built an extremely successful business effectively from nothing. And if you're not with me on summary judgment, then there is a real risk that that business is destroyed if there isn't an orderly way in which money can be taken out. So that's the 4th ground of appeal.
Can I tell you that we have read the skeleton arguments, we have read the judgment, we have read the pleadings, and we have read the witness statements. We have looked at, but I can't say studied, the exhibits.
Well, I'm very grateful for that indication. In fact, I won't be very long on the exhibits at all, but I'll have well in mind that you've read those documents and won't seek to duplicate the exercise. My lords, my lady, can I say this? The exercise that you are performing is one of review, albeit one where you are as well placed as the deputy judge to look at the evidence in writing and decide what to make of it. And what that means is that, of course, review is not a one-size-fits-all exercise. And in circumstances where you are as well placed as the deputy judge to look at what he looked at, then what you're not bound to do is to afford the same margin of respect to his conclusions as you would be if oral evidence had been.
I think we have to accord him some margin of respect, don't we? There's a Supreme Court case about parades in Northern Ireland, I think, which says that even where the evidence is all written, an appeal court ought to have some reluctance to interfere with the judge below, his evaluation of that.
My lord, there is a bit of authority on how the Court of Appeal approaches appeals from summary judgment applications. Oddly enough, it's not in the White Book, and I don't know why. But essentially what that authority says, I can certainly have it for you after the lunchtime adjournment if you want to see it, but what it says is that you're not constrained by any particular respect is often a bad word to use, but my lords and my lady will understand what I mean by that. You're not bound to afford respect to those findings because you are simply as well placed as the judge was. There is nothing missing from the exercise that's being performed here, apart from the fact that we've been rather more selective about some of the documentary exhibits in the bundles. There's nothing missing as compared to what the judge himself did below. And in fact, it seems to me that it's one of those cases where the distinction between a review and a rehearing essentially vanishes into the margins. Other than that, if I was seeking to introduce fresh evidence in this court, then I would have the Ladden-Marshall problem, but otherwise there's no discernible difference. My lords, my lady, what I propose to do is this. I want to make some very short introductory observations. That's point 1. Point 2, I want to consider what the judge said about his reasons for discounting the defendant's evidence. Point 3, I want to look at the reasons that the judge gave for not accepting the points made by the defendant about the reasons to look at the claimant's evidence with a sceptical eye. And on the basis of throwing those ingredients in the pot, as if they are not enough, I'm going to invite you to conclude that the exercise generally that the judge performed here was one that he was not entitled to perform. So let me turn straight away, please, to the judgment, just to see how the shape of it looks. That's page 103 of the core bundle.
Yeah.
And if one tries to just pick out from the judgment what the judge is in fact relying upon for the purposes of saying, well, this is one of those very unusual cases where I'm not bound to take the defendant's evidence at face value, and actually I can say I reject it and grant summary judgment. It seems to me the operative paragraphs really are 10, 12 and 13. In paragraph 10, at the beginning of paragraph 10, if we make it point 1 of the judge's reasons, he says, third line, common ground that the defendant's 2001 accounts do not record the alleged oral agreement, and there is nothing specific to that effect in the 2002 accounts. There is no evidence that the 89,250 shown in those later accounts as amounts falling due within 1 year from other creditors did in fact include the loans made in 2001. So it seems to me his point 1 is to say, well, the defendants are relying on an oral agreement made in 2001. And if you look at the accounts, there is nothing in them to necessarily show that loans were made in 2001 or indeed in 2002. So that's point 1 I will want to grapple with. We then go on to the next sentence. The contemporaneous documents do not bear out the existence of a shareholder's loan account as opposed to a director's loan account. So point 2 is the judge drawing a distinction between a shareholder's loan and a director's loan. So that's the second point I will want to deal with. And then there is quite a long passage that follows about the absence of documentary evidence corroborating the existence of the loan agreement. And one can really summarise that by looking, if my lords and my lady look halfway down paragraph 10, there is the line begins, the dearth of any documentation evidencing the alleged oral agreement is striking. So that's point 3 that I propose to deal with. And then we have point 4 right at the end, the last couple of sentences. The defendant's explanation for the statement in its audited accounts that the loans were repayable within 1 year, namely that there was always a prospect that they might be repayable within that period, is unconvincing. So that's what I take from paragraph 10. We go on to paragraph 12. And what the judge says in paragraph 12 is that there is inconsistency between the pleading and the evidence called by the defendant on the application. And it's not immediately easy to follow paragraph 12 because all of the numerical references to the witness evidence are wrong. But nonetheless, he's making the point that there is inconsistency. So I will be grappling with that. And then finally, at paragraph 13, what the judge turns to are points made by my predecessor, Mr. Campbell, to say, well, look, actually, there's quite a bit of evidence here which corroborates what the defendant says. That being, look at the 20-year period, and you can see that whenever these people took money out, they did it in equal terms. So if you look at the way in which the relationship operated in practice, what that tends to do is to suggest that there is unanimity. And what the judge finds about that is it's a neutral factor. And I say he's wrong to do that. So broadly, those are the points in the judgment that I will want to deal with. And I say, well, once you start chipping away at those, if my lords and my lady are with me on that exercise, then this is a judgment which can't possibly stand, because what the judge has done is take into account wholly irrelevant factors. He's built a house with defective bricks.
Yeah. Now, can I just ask you this, because it's puzzling me? Your case, as I understand it, is that there was a shareholders' agreement.
My case is it doesn't matter what you call it.
Well, I think your evidence is there was a shareholders' agreement.
Yes.
How is the company entitled to rely on a shareholders' agreement? Claim is against the company,
Yes.
Your defence of the claim is there was a shareholders' agreement. That's what the evidence is.
Yes. The company, of course, is a party to that. It has.
How?
Well, the three individuals who are making the agreement are all directors of the company.
But your evidence is that this has nothing to do with them as directors. They're shareholders.
Well, I don't say, my lord, it's nothing to do with them as directors. What I say about that is that the money comes into them as shareholders because they are reinvesting profits, and that is put into the company. I mean, all I can say about that, my lord, is that's a point that's never been taken against me. And no doubt if the point had been taken against me, then one would have joined the other directors as parties so that they would be in a position to assert their rights. But I don't think that's a point that can emerge for the first time on the hearing of this appeal. My lord, if I go back to the two initial points I wanted to make by way of introduction. The first is that, of course, I accept that there are cases where the documentary evidence, the contemporaneous evidence, is so one-sided that a judge is entitled to discount the witness evidence on a summary judgment application and say, well, this case has no credibility, it's fanciful. But those cases are going to be very few and far between. And the distinction between that sort of case and a case where the judge falls into the trap of weighing and balancing the competing evidence on both sides and deciding whose evidence is more attractive is a very thin one. And one has to look quite carefully to see whether a judge who expresses him or herself in terms of saying, well, I've decided that this case doesn't even meet the summary judgment threshold, is in fact just carrying out an exercise of deciding which side's evidence is more attractive than the other.
In effect, you say the judge conducted a mini-trial.
I do. I say exactly that. Just by looking at the exercise he did, which is saying, well, here are reasons why one might choose not to believe the defendant's evidence, and what I'm going to do is ignore or discount what the defendant says about the claimant's evidence. So when I weigh these up in each hand, then I've decided one is much more attractive than another. And that's in truth the exercise the judge was doing. And although there is a brief reference in the judgment to what I think is my Lord's judgment in Easy Air, there's no self-direction. He doesn't seek to draw principles from it. And particularly what he doesn't do is try and direct himself on the bar and where the bar sits. So it's all very well to recite Easy Air, but one, I think, has to go a little further than that, despite the fact that it's well known, I accept. One has to think about where the bar actually sits, and there's no evidence here that the judge did that. The second point to make is a point of fact, and it's an important one which permeates throughout this application and the appeal. What is the significance of there being no corroborative documentary evidence of the loan agreement? None. Leave to one side.
None.
None. Absolute zero. Leave to one side a point which classically arises in cases of this kind, which is that this was a familial situation. You have two brothers and a brother-in-law. In the 1990s, prior to this business being founded, they were driving around in a builder's van and somebody's wife was doing the VAT return. So this was about as informal an arrangement as one could possibly get. But I just invite you to put that point to one side for a moment. The more important point is that everybody in this case agrees that there was an agreement. That is common ground. The money didn't walk its way into the company. And everybody agrees that that agreement was not documented. It's common ground that it was oral. And just to put that point beyond doubt, if we look at the pleadings and the evidence, so we can see that in fact it was common ground that there was an agreement. If my lords and my lady look first of all at the reply, which is core 133. This is the claimant's reply. Paragraph 3 on 132, as to paragraph 7.1a, the director's loans were classified as such because that is what the parties agreed they were. If we go on to Mr. Malik's witness evidence, which will be in the supplementary bundle, page 9, and we're here in Malik 1, paragraph 8.
Sorry, I'm behind you.
My apologies, my
Reference
lord.
again?
Supplementary bundle, page 9.
Yeah.
And you will be in the first witness statement of Mr. Malik, and it's paragraph 8.
8. Yeah.
In what you might think is a surprising moment of very clear recollection by Mr. Malik, Tariq, Kashif and I agreed that these loans were made to Henley Homes by the three of us as directors. And if we go on, please, to Mr. Malik's... Well, Mr. Solomon wants you to read the next line.
Yes.
Please
not
do.
very specific terms. Yeah.
Yes. But the point, my lord, I'm making, nothing to do with that, is that everybody agrees there was an agreement. It's not... One frequently finds oral contract cases coming before the court where the argument between the parties is whether there was any contract made at all. You know, someone says something in a pub and the other party wants to jump on that and say it's contractual, and the question for the court is, was it ever actually said, and if so, was there an intention for it to have contractual effect? This is a situation where everybody agrees that there was that conversation about what the parties were going to do with their profits, and everybody agrees that they were going to be reinvested into the company. Mr. Malik says, well, actually, we got so far as to agree that these were directors' loans, not shareholders' loans. And it's common ground between the parties that none of this is documented. If we just go on in the exercise to the second witness statement, please, of Mr. Malik, page 89 of the bundle that my lords and my lady are in, paragraph 5. Second line of paragraph 5, my position is that the agreement between Tariq, Kashif and I was simply that the loans would be made by us as directors, but we did not agree any terms as to repayment. Paragraph 8 of my first statement.
Yes.
So what you have in the authorities bundle produced by the respondent are a number of the well-known authorities dealing with how the court should approach a situation where an oral agreement is relied upon, but there is no written corroboration. Unsurprisingly, it's often the case that the judge looks at the situation and says, well, it's pretty astonishing that someone's alleging to have made, e.g., a facility agreement with a bank, but there's no written document which shows it. That's not the way in which commerce works, and that's a factor which should be brought into account to discount the possibility that the agreement was ever made. But where it's common ground between the parties that there was an agreement, and where it's common ground between the parties that it wasn't documented, what effect do those authorities have? Absolutely none. It's just a question of what the parties agreed in their oral communications. Now, it follows from that that when the judge said, as I showed this court a few moments ago in his judgment, that the absence of documentary evidence was striking, it wasn't striking at all. It was a conclusion he couldn't possibly come to, even taking a generous view. What he's done is simply to repeat a point which arises in the oral contract cases without seeing through how that matched the facts of a case where it was common ground that there was an agreement that was not documented. It doesn't meet that kind of case at all. So just by way of introduction to one enormous flaw in this judgment, it is that. It's difficult to see how one gets beyond that, because that must have coloured the judge's view to everything then on in terms of what he thought about the evidence before him. And it was simply a conclusion that he was not entitled to reach. So, my lord, my lady, those are my headline introduction points. What I'll now do is turn to the second issue, which is the invalidity of the judge's reasons for rejecting the defence and the evidence in support. And I'll do that by reference to the points that I showed you in the judgment flowing from what the judge said. First point, what the loans are called. This was a 3-person business, and those 3 persons were both directors and shareholders. They wore both hats. So whether you call these loans directors' loans or whether you call them shareholders' loans is absolutely nothing to the point. Neither of those expressions are a term of art. They don't mean anything. They just mean money loaned by a person who occupies that position. And we know that
both parties in their evidence and their correspondence seem to have placed considerable weight on this label.
My lord, I entirely agree with that, but one has to then look at how that position dissolved in front of the judge. Of course, it's often the case that arguments are taken, positions become highly fixed in advance of a trial or an application. The judge makes a clever observation about something and all of that dissolves away because people realise that actually the point doesn't go anywhere. And I'll show you in a moment, though I'm sure my lords and my lady have seen it, how that's unfolded and the hearing in front of the judge, because everybody said this point doesn't matter, it doesn't take you anywhere. The point, just before we go to the transcript, is that these loans could only ever have been made qua shareholder, because what the parties were doing were taking their profits from particular property developments, whether coming out by way of dividends, distributions, some exercise of obtaining entrepreneurs relief, doesn't matter. They were taking those profits and they were reinvesting them back into the company and characterising them as loans. And they would only ever have those profits in their capacity as shareholders. So although
I thought, certainly at the outset, the profits came from the liquidation of separate companies in which they were shareholders, but not from their capacity as shareholders in this company. Am I wrong about that?
No, I think the position on the evidence is that most of the developments are done via SPVs. And
yes, but some of the SPVs are now owned by the company.
Yes.
But at the outset, I thought the SPVs were typically owned by the 3 individuals as individuals. So when they invest profits into this company, they're not doing it qua shareholders of this company. They're just doing it as individuals. I mean, I don't understand in what sense you say it can only be done as shareholders. It's done by the 3 men.
Well, because they are shareholders in the holding company, they set up SPVs with an equivalent interest in respect of individual developments, my lord. I see the distinction that my lord draws, but in practice, the reason why they are in the position that they're in is not because they're receiving remuneration as directors, it's because they are obtaining profits from this business venture, which seems to me in those circumstances actually to call it a shareholder's loan is probably a more suitable term. But on my case, and not just my case, on the claimant's case, it doesn't matter, it makes no difference. And one can see that once one recognises that no one is suggesting it's a term of art. It doesn't show anything. If my lords and my lady, we look at what happened in the course of the hearing, that will be page 132 in the supplemental bundle.
I can tell you straight away, Mr. Cohen, I have not read this transcript.
Ah, Well, I'm grateful for that indication. Then this will be a helpful exercise, I think, my lord. So the judge makes the observation that my Lord Justice Nugee made a moment ago, which is what's the importance of all of this? Why does it matter whether it's a director's or a shareholder's loan?
Right, where are you? 132?
Yes, 132. And if my lords and my lady look at the second paragraph on that page, which begins, "So when my learned friend."
Yes.
And if you count down 3 lines, this is Mr. Halban speaking on behalf of the claimant.
Doesn't matter, he says.
It does not matter to the claimant whether the loan is either a director's loan or the shareholder's loan. Deputy Judge, well, I was going to ask you about that because there is a lot of emphasis on it. Mr. Halban, there is. It is an issue which the defendant has raised. And if my lords and my lady go down a little further, there is a passage, Mr. Halban. In fact, what I might do is just invite you, rather than taking out selected parts, if I could invite you to read from this to 134.
Yeah.
You'll see where it ends quite naturally. It's probably helpful to have a look at that.
I've got to the middle of page 134. Do you want me to go further?
No, that's the end of this exercise. Now, my lords and my lady, I should say I accept straight away that a judge is entitled to change his or her mind. So it follows that looking at what the judge says about his or her conclusion in the course of submissions does not necessarily bind the judge to what ultimately arrives in the judgment. But this is not that situation. This is a situation where both counsel have said to the judge, this point just doesn't go anywhere. And no counsel has said to the judge, actually, this is very important because what you should draw from the distinction is X, Y, or Z. They've said the opposite of that. So in circumstances where both counsel have said, this doesn't matter, and the judge has said, yeah, okay, I accept that, then there's no basis whatsoever upon which the judge could then, in the judgment, have said, actually, this is a point that matters, and I'm going to use it as one of the 4 factors on which I discount the defendant's evidence. Lord, next point, the accounts. And you will remember that what the judge said was there's no record of any loan in the 2001 accounts, and in the 2002 accounts there is a figure of 89 odd thousand, but I've got no evidence to suggest that encompassed within that was any loan amount from the directors. And one just starts for a moment by reflecting on what possible significance any of that might have. I come back to a point I made in my introductory observations, which is that it's common ground that the loans were made. And it's common ground that there was an agreement to make those loans. There's just a dispute about what the terms were. So even if, in fact, let's assume for a moment, which I don't accept, but let's assume for a moment that Mr. Usmani's evidence was wrong, and in fact the agreement was made in 2002 or even 2003. It is, I suppose, just about a cross-examination point to put to him at trial that a fault in recollection about the date might read over to a fault in recollection about what was agreed. But it's certainly not a basis to just throw the baby out with the bathwater and say, well, I'm going to reject his evidence altogether. That would be an absurd approach to take. But in any event, I don't accept that what Mr. Usmani said was wrong. If one looks, first of all, at the defence, which is page 125 of the core bundle, the pleaded case at paragraph 3.1 is that the agreement was reached in or around 2001. And it's not surprising to see that kind of terminology used when one is dealing with an oral agreement that was reached over 20 years ago. Not surprising to have some lack of precision about precisely what the date was. If one then goes to page 61 of the supplemental bundle,
Sorry, page.
61.
It's a bit more specific than that, isn't it? Because at 8.2 is pleaded in or around 2001. It was already agreed that each of the shareholders would loan an initial amount of approximately 10,000.
Yes, yes. It's a little bit more, but I was going to take you next to the 2002 accounts. Can I simply do this, which will help with my Lord's point? If one goes to page 22 of the supplemental bundle,
Yes.
we have the beginning of the loan ledger.
Yes.
My lords and my lady, I'm sure have seen this already.
Yeah.
But what it shows you is that when the ledger opened, which was 31 December 2003, there was already a balance of just over £25,000, which is not very far away from the 3 times 10, which is dealt with in the defence. Maybe that some money had come out for something. And it tells you that that money was already in prior to 31 December 2003. But as to when it goes in, the precise date, no one can be sure.
Do we have any explanation of what the column-headed type is? JC, PI, and so on?
I don't, but I'll take instructions, my lord, and see if I can get one.
Well, I don't really want more evidence. It wasn't below, but I just wondered if there was anything in the evidence.
There was nothing in the evidence.
No, thank you.
So we know that there was already loan money in the company by this date.
Sorry, I'm not quite sure I have quite followed this point. The ledger is covering the period from the 1st of January 2003 to the 31st of December 2003.
Yes.
The opening balance is at 31st December, not 1st of January.
No.
So, but you are saying, are you, that there was an opening balance on the 1st of January 2003?
No, I'm not saying that. I don't know when there was an opening balance.
But if the ledger is correct, and your case is correct, there ought to have been an opening balance, oughtn't there, on the 1st of January?
Yes, the problem is I can't tell you whether there was or whether there wasn't because I don't have any evidence for it. I'm simply making the observation that it appears from the ledger as if there was already money, well, inevitably there was already money in the loan account.
Well, there was on the 31st of December.
Yes.
But the ledger doesn't show any money before that date.
No.
And you might have expected it to, since it's covering the period which begins on the 1st of January.
Well, you might have. I don't know the answer to that. I put the point no higher.
Yeah.
than there being some evidence for the proposition that there was money in the loan account prior to that date. No higher than that. In addition, we have the 2002 accounts.
Yeah, so this is page, you're page 61.
61. And at paragraph 13, we have other creditors, the penultimate line. And there is 89,250 in 2002. And there is no evidence from either party as to what went in that sum. But certainly we know, and is common ground, that the director's loans were recorded under that line in box 13 of the accounts in all subsequent years.
I thought the point was that there was no reference to related party transactions, which is what you would have expected if there'd been a director's or shareholder's loan. Have I misunderstood that?
Well, I just think the judge was saying he had no evidence that within the 89,250 was any sum in respect of loans. He couldn't see the £30,000 in there. I don't think he was anchoring his finding to the fact that there was an absence of reference to related party transactions. And certainly, my lord, and it's a point I'll come to in a moment, there was no evidence in front of him about financial reporting standards as to what the accounts should or should not have said in respect of these loans. But if one goes back to his judgment, at paragraph 10, core bundle 106, if one looks at the 1, 2, 3, 4, 5th line of paragraph 10, he says there is no evidence that the 89,250 shown in those latter accounts as amounts falling due within 1 year from other creditors did in fact include the loans made in 2001.
Well, that is true, is it not? I mean, there wasn't anything to say.
I entirely accept that, but it's not. This is in a passage where what the judge is doing is weighing up factors which he says are inconsistent with the defendant's case. If there is no evidence for it, it's not inconsistent with the defendant's case.
Well, there is, isn't there? Because the 2002 accounts on page 61 are comparing 2002 with 2001, and the reference back to 2001 shows you that there were no loans.
Yes, but the pleaded case is that...
You say on or around.
I do. Yeah. In fact, when one looks at Company's House, the claimant didn't become a director until August of 2001. So one can well see that there's every possibility that this is an agreement that's reached in early 2002, and that's not incompatible with the pleaded case. And it would be entirely compatible with the accounts. One doesn't know the answer for sure because we're trying to reconstruct events that happened over 20 years ago. And it may be possible at trial for there to be a reconstruction of the accounts because it may be possible to get hold of bank statements. I can't say it will be possible to do that because I don't know how much will be retained, but I'm not suggesting it may be entirely.
So you were focusing on the sentence in paragraph 10 of the judgment, but that sentence seems to me to be correct. I understand your point, well, it may be correct, but that's not inconsistent with the pleaded case. But as a matter of fact, it is correct, isn't it?
My lord, I absolutely agree with that. I'm not suggesting that what the judge says here is not right. There was no evidence for it, but that's not a factor that counts against me for two reasons. First of all, because it is consistent with the pleaded case, and secondly, because if in fact it was going to be said that the 89,250 positively doesn't include the sum, and that therefore counts against the defendant's case, then it was the claimant who bore the evidential burden of making that point out, not me. And what the judge has done is put that in his mix in paragraph 10 of his reasons for saying, well, I can discount the defendant's evidence, and that's not an appropriate exercise. He's wrong to do that. So that deals with the issue of the date of the agreement. Then we come to the judge's point at the end of paragraph 10.
Just before you leave that, you made some passing reference to all the accounts from 2003 undoubtedly showing the director's loan accounts. Do we have an example of the post-2002 accounts and how they were treated in those accounts?
Well, we don't have examples close in date, but I can certainly show my lord the 2021 accounts to see how they're dealt with by this stage. I accept it's a lot later. If my lord goes to those accounts, begin in the supplemental bundle at page 190.
Thank you.
And if my lord goes, please, to page 233.
So these were what, the most recent accounts at the time of the hearing?
Yes.
233.
233. At the time of the consequentials hearing, I think. They may have been available in draft, if I remember correctly.
Right.
233, box 22.
It's the other creditors.
The other creditors. And it's common ground between the parties that includes those loan balances. And then if my lord goes to 239, at box 32, the penultimate line of box 32.
That is under the heading related party transaction.
Yes.
When one looks at the 2001 2002 accounts, there is a note to each account of related party transactions, but doesn't contain any similar reference. That was, as I say, I think I must have picked this up from Mr. Solomon's skeleton in a footnote. The point that was being made, although I entirely accept it's not a point that features directly in the judge's judgment.
In order, my lord, for that point to go anywhere, one would have to do quite a lot of construction. First of all, one would have to have an understanding of what FRS required in 2001 in terms of related party transactions. None of that, of course, before the judge. And assume for a moment that what it did require was that directors' loans would be listed within box 32. One would then have to build on that to suggest that it shows that the accountants were not given information about the loans at that point in time. So what that shows is that there were no loans until 2002 rather than 2001, or 2003 rather than 2002. There's quite a lot of building there, none of which the judge did, and none of the evidence was before him.
Thank you.
But we do have Mr. Laller's evidence, don't we?
We do.
That the way that the accounts look now is how they've always looked since he joined in 2013.
Yes, we do. We do. My lords, my lady, I'm going to turn next to the issue of the way in which the loans are characterised in the accounts. In other words, appearing as they do in creditors' amounts falling due within 1 year. And one has to start by thinking about how this point arises, because certainly the judge doesn't explain in his judgment really anything about why he attributes significance to this. One must assume, for the purposes of what I think is the submission made against me, that at the relevant time, the financial reporting standards would have required a loan that was repayable on demand without there being any conditionality to be listed in the accounts as falling due within 1 year, but a loan as characterised by the defendants, in other words, repayable only with unanimity, to be characterised as an amount falling due after more than 1 year. And one would then have to infer from that that the company's accountants must have been told that this was a loan that was repayable on demand without the need for unanimity, which is why they've drawn the accounts in the way that they have. And they would have to be the building blocks that the judge was using in order to say, well, I can then discount the defendant's evidence on what the loan agreement actually was because the accounts conflict with it. And you find none of that in the judgment. Indeed, you don't seem to find any of it really in any of the argument at the hearing in front of him. But I want to deal with whether the judge could have reached that conclusion. The answer is no, and I'll show my lords and my lady why. If we go back to the judgment at paragraph 3, which is core 104, what the judge finds in the second line, well, if one starts at paragraph 3, the first line, he begins, "It is common ground." And he recites a number of matters that he thinks are agreed between the parties. And in the second line at the end, that the loans are repayable on demand. And he's right to say that, because everybody agrees that they are repayable on demand.
Well, is that right?
It is right.
Isn't your paragraph 9.6 of the defence? Shareholders' loans would not be repayable in full to the shareholders unless and until the occurrence of a sale or liquidity event or repayment was unanimously agreed.
Yes.
That doesn't sound like a demand, but
Well, everybody has to join in the demand, but providing they do, then the loan is repayable on demand.
It's not a joint. It's not a loan owed to the three of them jointly.
Well, it's
three
placed,
individual loans, is it not?
it's placed into a joint loan account.
Yes,
my lord.
but my understanding, we haven't looked at the ledger. My understanding is that separate amounts are credited or debited to each of the three of them because they draw different amounts for different things.
With a true up every so often to equalise. So the money is mixed into a mixed fund. It is right to say that on occasion different amounts are drawn out, and then as Mr. Lala says, there is a balancing amount, so everybody ends up equal.
Yes. So as a matter of law, you can't say this is a single sum owed to A, B and C jointly. It's three different sums owed to each of A, B and C.
Well, my lord, I would say that that's too sophisticated an analysis to apply to a simple situation, which is what these individuals do is they plough all of their profits back into one account, which is to be used to fund the business, and they agree that insofar as money is going to come out, that's going to require unanimity between them. And so it follows that the loan is repayable on demand because at any time repayment can be demanded. It just has to be demanded by all of them together.
I think my lord's point is it payable to them in equal shares? Is it a single loan payable to the three of them jointly in equal shares?
Well, it is possible that at the moment of the demand, the sums might be unequal because there hasn't been recently a true up to make them all equal. But
they're individual.
But also, I mean, I don't think there's any dispute about this. The way the account is actually operated, was actually operated, is there are monthly drawings, which are usually equal, but there were circumstances in which they weren't. There are payments for things like medical insurance and car payments and so on and so forth. And then there are quite substantial payments, one-off payments, if people want to renovate their properties, all of which, and I think this is the evidence, all of which are agreed, but they're not equal payments. It's not we're each going to draw £10,000 for our cars. It's I'm going to draw this, and you're going to draw that, and you're going to draw the other, which is why there are reconciliations. So picking up my Lord's point, you're right, it may be a simple situation, but one still has to analyse what it is. And there is in law a real difference between money owed to A, B and C jointly, where they each have an equal interest in each pound that's paid out, and money sitting in an account which is owed to the three of them separately. And I do think we do have to at least ask the question which this was. And I myself would have thought it was fairly plain on the evidence that it was owed to the three of them separately. There are separate amounts owed to them, albeit there's one ledger which records all that. But if you want to say that's wrong, then do please tell me I'm wrong.
No, I don't think I want to say that's wrong.
But then it is a slightly unusual arrangement, in which money is owed to each of A, B, and C on terms that A can only be paid his money if B and C agree. That doesn't look to me like a loan repayable on demand. It looks to me like a loan only repayable if B and C agree, which is not quite the same thing.
Well, one has to remember that the agreement of B and C also affects their position.
Oh, undoubtedly.
So,
yes, there's no suggestion of any different treatment to any of the three of them.
So that explains the commerciality of the situation, because they are all agreeing that insofar as money is going to come out, they'll treat each other equally. But they could decide together at any time that they were going to demand repayment from the company. It just requires them to make that decision together. And if that is what they agreed, unusual though the arrangements may be, that is what they agreed. Now, that doesn't transform this to a loan that was not repayable on demand. It was repayable on demand. To come back to the point made by my Lord Justice Lewison, of course, I do accept that the company is a different person to the three directors, and what it's bound to do is to act on the demand. It's just a situation here where the demand has to be made by all of them together, because there needs to be unanimity according to their agreement. So in those circumstances, the judge is right at paragraph 3 to say that these were loans repayable on demand. That was common ground, and that's the way it was argued below. Now, once one recognises that this was a loan that was repayable on demand, its treatment in the accounts becomes rather obvious, because the company wasn't in a position to say, we're not going to pay. The company was bound to pay if the demand was made in appropriate circumstances. So to any third party reading the accounts, they've got to be told that this is a loan which will fall due within 1 year, because that demand could be made at any time. The judge at paragraph 8 of the judgment, page 105, recorded the submission being made by Mr. Campbell in the first 3 lines as a submission that the loans were properly recorded in the accounts as repayable within 1 year, because there was always a prospect that they might be on both parties' respective cases. And that's a not entirely satisfactory record of what was said to the judge. If one goes to the supplemental bundle at 149, please. There is a passage of Mr. Campbell's submissions between the 2 hole punches, and it begins with, "Indeed, and what I say on that, my lord." Yes. I could invite my lords and my lady, please, to just read that paragraph.
Yes.
And then at 150 over the page, there is another Mr. Campbell, a rather longer passage.
And that is why I say.
Yes. Yeah. I can invite the court to read that, please. And you can see just below it the deputy judge saying that he didn't follow the submissions, and Mr. Campbell returns to it by saying that neither side had accounting evidence to assist, but the basic point, which I do not think is controversial, is that when you have a loan, when you're a debtor on the loan and you're preparing your company accounts, then you have to consider whether you might have to repay that within 1 year. And at the bottom of the page, Mr. Campbell says, when one prepares these accounts using the relevant standard. And I accept that the standard was not, in fact, before the judge. Nobody sought to produce anything from FRS in respect of the accounts. But the important point about that is that the evidential burden was the claimant's, not the defendant. And clearly the way in which the accounts would deal with a point like this is not simply a matter of an accountant sticking a finger in the air. As with every feature of accounts, it's carefully prescribed by accounting standards. And this judge had no accounting standards in front of him. Nobody sought to do that. And if the claimant wanted to build this case by saying, well, look, as a platform on which we are constructing the argument, what the accounts show is that the claimant could demand repayment at any time without the need for unanimity, without any precondition, then they were bound to show the judge why that was so, with some evidence
about it. Can I just pick up that point? You said the evidential burden was on the claimant. That may be quite a significant difference between you and Mr. Solomon. What he says is, all I need to show is that I lent money to the company. And if nothing else is shown, then that money is repayable on demand. As far as I know, that is the law. So he says the burden is actually on you to show that it is not repayable on demand, that there is some, repayable on demand by the person who lent the money. And it is, he says, therefore, for you to show that the loan is not repayable simply on the demand of the person who lent the money, but there's got to be the concurrence of two other people who didn't lend the money before the loan is repayable. So where the evidential burden lies may be an issue between you.
Yes, and I should say straight away, I accept that the burden would lie upon my clients to establish the existence of the agreement. That is true. But the reason why I say the evidential burden lies upon him is for two reasons. First of all, because on a summary judgment application, the evidential burden lies on the applicant to establish that the defence, as the case may be, doesn't reach the necessary threshold of arguability, point one.
Is that right? Is there some authority about that?
Well, it's certainly dealt with in the White Book. EDF and Mann is, I think, authority. In fact, I'm sure is authority for the proposition that the evidential burden lies on the applicant. But leaving that point to one side, if a party in the course of litigation is seeking to make out a particular argument, to say this piece of evidence favours my case, then they necessarily bear the burden of proof in establishing that it is so. It's not sufficient to look at the umbrella burden and put everything on me, or I'd be establishing a negative. If, in fact, the claimant's argument is you can discount the defendant's evidence because a feature of these accounts shows it to be wrong. Of course, there'll be cases where the accounts have words in them, and you could read those words and see what they mean without more. But where, in fact, you're looking at technical features of accounts and you're seeking to establish that they show something, well, you, the party making that argument, is the one bound to make it good. Yeah, and it was for the claimant to put in some evidence if they chose to do so. Now, I don't say that at trial this would necessarily have needed expert evidence from an accountant, but what I do say is that at the very least, the parties would have had to have put in the relevant financial reporting standard so that the judge could see in practice how this box of the accounts actually work. I'm not in a position to file further evidence. I've looked at FRS and I'm quite confident about the way it works, but that wasn't before the judge, I accept. So a finding that the judge just was not entitled to reach, and you can see, I think, that the judge had some reluctance about it, because if one goes back to paragraph 10 of the judgment, or 106, the word that the judge uses in the penultimate line of paragraph 10 is unconvincing. And it's difficult to know quite what he means by that. First of all, if by unconvincing he's saying the burden was on the defendant to convince, that was wrong. But it's not a point that's properly addressed by using the word unconvincing. Either the accounts are consistent with the defendant's case, or they are inconsistent with the defendant's case. In other words, either they accurately record the type of loan that the defendant says was made, or they don't. And that's a binary exercise. And the judge seems to have been reluctant to commit to one side or the other, simply using the language of unconvincing, which we say is precisely because he doesn't have the evidence to do it. And the fault for that, if fault is the right word, lies with the claimant, not with the defendant. So that, my lord, is what I want to say about the reasons given by the judge in paragraph 10 of his judgment for discounting the defendant's evidence. What I now want to do is...
Just before you move on, I've looked at the white book, what it says about burden of proof, and you're right. EDF and Mann says the overall burden on an application under Part 24 is on the applicant, and what you have to show is there's no reasonable prospect of success. But it does go on to say that if the claimant makes that a prima facie case, then the evidential burden shifts to the defendant to put forward something to show there is a real prospect in his case, which doesn't seem to me at all surprising as a statement of the law.
Well, my lord, I think, first of all, the reference given there in the White Book is to a first instance decision from the TCC, if I remember correctly. Might be wrong about TCC, but and one has to be a little careful about that. You don't see that proposition of a sort of reverse burden being cited left, right and centre in summary judgment applications. On the contrary, I think you very seldom see it being cited. The safest proposition is to work on the basis of the burden sitting with the applicant. Well,
the overall legal burden, which I don't have any difficulty with, but I mean, going back to Order 14, it was absolutely standard. The defendant has to come up with some evidential basis for their case in order to defeat an application under Order 14. And it's exactly the same under Part 24. If the claimant says this is an open and shut case, the defendant has to come up with something, only an evidential burden, to say, actually, no, I do have a case with some real prospect.
I'm not suggesting otherwise, my lord, but we don't get to that stage with this point. Because
no, I understand that. That's a separate point.
Yes, well, I accept that, my lord, but I won't repeat myself, but for there to be a suggestion that the burden was on me to come along with some form of accountancy evidence, not necessarily expert evidence, but to produce the financial reporting standard, etc., is a step too far. The claimant was bound to do that if they thought there was anything in this point at all, and for the judge to look at that and reach a determination. And the only thing that the judge could have done in these circumstances was to say, well, there is an evidential vacuum in front of me because I've got accounts that deal with something in a particular way, but I've got no evidence as to whether that way is consistent with the claimant's case or the defendant's case or both of those cases. And in those circumstances, I can't find that it's anything more than a neutral factor. It's not something which I can use to discount the defendant's...
The way it works, I think, sort of on the facts of this case, are the claimant says, I lent money to the company. Yes. That's all I need to show. Absent anything else, it's repayable on my demand. You come along and say, no, we had an agreement that all three of us would have to agree for you, claimant, to be repaid. Claimant then says, well, the accounts are inconsistent with that. At that point, the evidential burden is on the claimant to show the accounts are inconsistent with your case.
Exactly that. And I agree with that. That's my submission in a nutshell. My lords and my lady, I was going to move on now to deal with paragraph 12, unless I can help any further with my paragraph 10 points.
Yeah.
I come to paragraph 12, and paragraph 12, page 107 of the core bundle, is not necessarily easy to follow because the judge's references to the paragraphs of Tariq's statement are not accurate. So it's not precisely clear what the judge was looking at. But let me try and translate from this what the judge was finding and why he was wrong to do that. What he says is that what Tariq's statement says about the agreement is not consistent with, or not wholly consistent with, the defence or pre-action correspondence. And he also says that there's deficient particularisation of when and how the alleged oral agreement was made. And I should say I accept straight away that what the CPR requires by virtue of the practice direction is for a party to set out the words that were used and also the occasion on which they were used, and that's there for perfectly good reasons. But what the practice direction doesn't acknowledge is that there will be cases where that's extremely difficult, if not impossible, to do, either because it's a very long time ago, nobody remembers precisely the language that was used, or because there are some cases where agreements are made over time and not necessarily one incident where everybody sits down and works through the situation. It must mean that a party does that if they can do it. And of course, it might be said at trial that an inability to do it is a matter that the judge should take into account in deciding whether or not the agreement was reached in the terms that were suggested. But it's not a reason at the summary judgment stage to say that a case can't go forward to trial. I suspect that cases where people can remember the precise language used in an oral agreement reached 20 years earlier will be few and far between, but it doesn't mean that that party can never succeed on their case which seeks to establish the existence of the oral agreement. People will often remember the gist of what was agreed, but not necessarily the precise language in which it was. So I don't suggest that the judge is wrong to make the point that the precise language is not identified, but what he ought to have done was balance that by saying, but that's not necessarily an unusual thing in a case of this kind and is not a reason for ordering summary judgment in a case of this kind. And he also, at the end of paragraph 12, which I will need to deal with, says...
I mean, you might expect a bit more than is A, pleaded, and B, in Mr. Ismani's evidence. You might expect him to say, well, I can't remember exactly what we said, but I do remember we were sitting in the sitting room of so-and-so, and I do remember that the meeting, our discussion lasted an hour or whatever it is. There's almost nothing of context, well, either in the pleading or in the evidence. I mean, the pleading may be different, but the evidence.
Well, there are a number of quite well-known commercial court cases which address agreements made, for example, over time, addressing situations where you can't point to one incident where everybody was sitting in the living room of Mr. Smith's house and thrashed out the terms between them.
But then you might expect the evidence to say, well, we had a number of discussions about this before we eventually reached a consensus that whatever it was.
Yes, the essential thing to do on a summary judgment application is for the witness to set out what he or she claims was agreed. One doesn't have to go further than that, given the low hurdle. I agree with my lord that it would be helpful if more was said, and if in fact what happens at trial, assuming that we get there, is that Mr. Osmani elaborates on what was said, it might be put to him in cross-examination that the absence of the elaboration in his witness statement for the summary judgment application is something that ought to be held against him in terms of the truth of what he says. But it's not a reason to suggest at this stage that there is no triable issue. Indeed, if all that was happening here is that Mr. Osmani said, well, I'm relying on paragraph 9, as I think it is, of the defence, that too would be sufficient, because at least for an interim application of this kind, the defence itself is evidence. But it does go rather further than that, and I'm going to, I know that my lords and my lady have read Mr. Osmani's witness statement, but I'm just going to take a moment or two to pick out some key points of it. Just before I do that, could I show my lords and my lady the last sentence of paragraph 12, where the judge says, paragraph 31.1 of Tariq's statement itself refers only to what is alleged to have been the intention that the loans would be on the terms set out in paragraph 9 of the defence. And I think what the judge is saying there is, I'm going to ignore or discount what Mr. Osmani says in paragraph 31.1 because he uses the word intention and he doesn't say this is actually what was agreed. And so we're going to have to look at paragraph 31.1 to see if that was a fair way to approach the evidence. So in the light of that, my lords and my lady, if we could go to the witness statement, please. It's paragraph 18.
Paragraph?
It begins, sorry, page 75 of the supplemental bundle.
Yeah.
And if we could start... In fact, if we begin at 28 and 29, that's probably a helpful place to start. So, page 80. Paragraph 28, Mr. Osmani
Then we
says...
have to start at paragraph 13.
Yes, I'm only starting at 28 and 29 because it grapples with that intention point, which I raised last. Yeah. And it may be convenient just to dispose of that, and then I will go to the earlier paragraphs. Yeah. But 28, as set out above, the loans which form the subject of this claim were always intended to be on the terms set out in paragraph 9 of the defence. And then 29 in particular, the loans would not be repayable in full to the shareholders unless and until, and you'll see numbered paragraphs 1 and 2. Now, what the judge says about that is, well, the use of the word intention, or I think what he says, he doesn't explain it, but I think by inference what he says is that the use of the word intention suggests that, in fact, this is a sort of pipe dream of what the agreement could have been, what Mr. Osmani would have liked it to have been, but he's not saying that's what the agreement actually was. And that's plainly not what's being said in paragraphs 28 and 29. It's a verification of paragraph 9 of the defence. And indeed, it's not the only place where that is done.
Well, paragraph 28 starts as set out above. That
yes.
is to say, I am summarising what I've already told you in my witness
yes.
statement.
Yes. Well, I accept that, but there's certainly a verification of paragraph 9, and the terms are set out again. And the use of the word intention is in respect of the making of the loans. It's not intention to make a particular agreement, which is not fulfilled.
It's not obvious to me that that's what the judge meant by paragraph 12. I'm not sure. I'll just put this to you as an alternative, which is what he's dealing with in paragraph 12 is a lack of particularisation. In other words, it doesn't say in the defence when and how the alleged oral agreement was made. And then he carries on. It doesn't say that in the witness statement either. It doesn't say it was made on this occasion at this place, and that's when we agreed it. And if you read it that way, and when he says paragraph 31.1 just refers what's alleged to have been the intention, brackets, and you don't find there any particularisation of when and how, or in what words, or what was agreed, and so on. It's said to have been agreed. Then it doesn't. And that's a slightly different point, isn't it? Is that?
Well, if that's what the judge had said, but my lord, I just take from the last sentence, from the words, if one counts up 3 lines, itself refers only to what is alleged to have been the intention. I think the use of the word only and then the reference to intention must be because the judge is saying, well, I can effectively ignore what those paragraphs say because what they are doing is reciting an intention rather than what the witness claims was actually agreed. So that is my reading of it.
And do you accept when he says paragraph 31.1, he must mean paragraph 28?
Yes, I do. All the references are wrong.
Do you want to give us what you say the references should have been?
Yes, what I'll do then is from the beginning of the witness statement go through what I say the relevant passages are.
Yes, I see. Thank you.
So if we begin at paragraph, my lord said paragraph 13, I think paragraph 13 deals with the periodic reconciliations. But
paragraph 13 of Mr. Mali's witness statement says, in around 2001, claimant, Kashif and myself already agreed.
Yes, I'm so sorry. I'm so sorry, my lord. I was looking at the wrong witness statement. Yes, and
I think that's where we start.
Yes.
Then he goes on.
That doesn't.
In paragraph 19 to say there
Yes.
was an agreement reached at the outset of our business relationship.
Yes.
21, he says no expectation it will be repaid given the agreement which had been reached.
Yes.
And then 25 he says in setting up this system we all agree that living expenses could be funded. So that's where you get what he says about the agreement itself, I think.
Yes, and 30 I think one also
30?
has to look at.
Yes, what was agreed, yes.
We would only realise the cash when agreed it was needed. Or it's an ultimate sales stroke winding up the business.
Yes. So the basic principle is one of unanimity, and you see Mr. Osmani dealing with that in a number of passages of his witness statement. And it's very hard to reconcile that with what the judge says in the judgment, because the judge in the judgment at paragraph 12 only refers to paragraphs 9, 13 and 31.1. And none of those paragraphs, in fact, are the paragraphs which deal with the terms on which we rely in the present case. So paragraph 12 of the judgment is rather a troubling paragraph, because what one cannot do is determine precisely what the judge did bring into account in reaching the conclusion that he did. It's all the more troubling because, of course, this wasn't an extempore judgment. The judge reserved and went away and wrote it, yet still we have a passage like this which doesn't inform the parties as to how the judge reached this conclusion. But in any event, what I say is that when you look at Mr. Osmani's witness statement, accepting as I do that he doesn't say very much about the place or time precisely at which this agreement was reached, what he does do is tell you repeatedly that his recollection is that there was an agreement for unanimity. And that's entirely consistent with the pleaded case. The pleaded case, of course, has more polish to it because it's been pleaded by counsel. And what the witness has done is give you a raw account in his own words.
Yeah.
So it was quite wrong in paragraph 12 for the judge to say, well, I'm going to find inconsistency and that's a reason for me to reject this case without trial, in circumstances where there was a great deal of meat on the bones in terms of what the evidence would be for challenge at any subsequent trial.
Can I ask you another point, a different point? I was just looking at, prompted by my lord, at what Mr. Ismaili says in paragraph 25 about drawings and so on. Effectively, by unanimous agreement, the amount of these payments is periodically changed.
Yes.
I assume that the two Messrs. Ismaili are still drawing their monthly payments.
And the claimant.
Well, that's what I was going to ask you, because I thought it had been suggested that the claimant's payments have been stopped. Is that wrong?
Can I just take some instructions? Sorry, my lord, I do apologise. I'm just trying to... Yeah, yes, they have stopped, but stopped for everybody.
So no monthly payments are being made.
That's correct. There's no breach of unanimity, which is what I had understood.
Sorry, I interrupted you.
My lords, my lady, that's what I wanted to say about paragraph 12 of the judgment. And then the final passage I wanted to deal with is paragraph 13, which is where the judge, in case it's not open, core 107, is where the judge has had submissions made to him about factors to bring into account in support of the defendant's case. And the judge says, well, I regard those factors as neutral. And the only one that he refers to in paragraph 13 is unanimity over the 20-year period. In other words, everybody being treated in the same way for a long time. And he says that's a neutral factor. It's not. And it's not for this reason. What it tends to suggest, I agree, it's not absolutely conclusive on the point, but what it tends to suggest is that there was an agreement between the parties that they would be treated equally, and that any decisions about the withdrawal of funds would be made jointly. Now, it's not a very big step from that to think that the parties also discussed generally what they would do about withdrawals, because essentially it amounts to the same point. And that would no doubt be critical for a judge at trial to weigh in the balance in terms of deciding whose evidence to believe following cross-examination. One surprising feature of this case to date is that what the claimant has done is say nothing about what he says was agreed. Now, what do I mean by that? Well, we know, because I showed you at the very outset, that the claimant accepts there was an agreement. He goes so far as to say we specifically agreed that the loans would be directors' loans, not shareholders' loans. So we know that there was an agreement. But what he hasn't done is put his head above the parapet and say, well, this is what we spoke about. This is what we agreed. We know there must have been something.
Well, I thought he said we didn't agree anything.
Well, he doesn't say he didn't agree on anything because he says in
He
terms.
he agrees he agrees that there was an agreement to lend money to the company, but I thought his evidence is that that's all that was agreed. We didn't agree anything else.
Paragraph 8, page 9.
Well, my lord, if we.
Yes, we did not agree specific terms.
Well, my lord, if we just stop at my lord's first sentence, which is that we agreed to make loans to the company,
Yes.
there is an agreement.
Right.
And what he hasn't done is say anything about himself, about the language of that agreement, the context of the discussions. Now, they would all be very important points for the judge to weigh in the balance at any trial. But it does go further than that, because my lord and my lady will remember that when I took you to his evidence, both his evidence in support of the application and his reply evidence, he says that there was an agreement that these would be director's loans, and he underlines the word director. So it follows from that he does accept that there was something more agreed than simply we will advance loans to the company. But as to what in fact was the subject of discussion, he tells the court absolutely nothing. Now, in circumstances where one can add to that the fact that over a 20-year period there has been, it appears, the observance of unanimity, what is his evidence going to be? We have no idea. Is he going to say, well, actually, I can't remember what was agreed? Because that would be very important to weigh in the balance.
Yeah.
But the court doesn't know because he hasn't pinned his colours to the mast. And I would suggest that that's a pretty extraordinary situation on a summary judgment application where the court is trying to determine what the position might be at trial and is being asked effectively to shortcut the process and deliver a judgment in advance of that. So when the judge at paragraph 12 essentially said there's nothing to support the defendant's position, that wasn't right. There was a lot on the other side of the scale.
13, you mean?
13, I'm sorry. That there was nothing on the other side of the scales. Well, he was wrong about that. There was a great deal to support the defendant's position, and what the judge didn't do was weigh any of that in the balance when he was bound to do so. So that was another relevant factor that the judge left out of the equation. Now that, my lords and my lady, brings me to the end of what I want to say about the summary judgment part of this appeal.
So just pausing for a moment, you told us in your route map that you were going to show us why the judge was wrong not to look at the claimant's evidence sceptically, and that's your paragraph 13 point.
It is. And what I say
That's
about
the lack of context that he gives in his witness
well,
statement.
I say essentially three things, if I can summarise it this way. First of all, what the three men were doing was agreeing effectively to defer the taking of profits and to reinvest those for future growth. It was in effect thin gruel in terms of their ongoing living expenses for future profit at some later date. And it seems in those circumstances very surprising that they would not have discussed something about how the money would come out. So when a judge is weighing up the probabilities of the situation, which is a critical part of the judging exercise, then that is something that would have to be taken into account. And this judge didn't do so. Point one. Point two, you will already have, which is equality and unanimity over a 20-year period, which is inconsistent with the claimant's case that nothing else was agreed. If in fact he's wrong about that and equality and unanimity was agreed, then that's not very far away from and might be equivalent to our case on what was to happen on the way out. And the third point is the absence of any evidence from him as to what he says were the discussions giving rise to the agreement. He says nothing about that. And in circumstances where you've got silence from the party seeking summary judgment, it is reasonable to think that their evidence might be subject to some sustained challenge in cross-examination at any trial. And you find none of that reflected in this summary judgment. Indeed, so far as there's any of it, you have a judge saying, well, I regard the 20-year period of equality and unanimity as being a neutral factor. And I say the judge was wrong to find in those terms. So, my lords and my lady, that's what I want to say about summary judgment. Unless I can assist you further on those points, I still have the time to pay ground to deal with.
No, thanks.
I did have one other question. One of the points made against you is this. The way in which the parties have run this business for 20 years, you've just explained, is they've reinvested all their profits. It's not perhaps surprising if relations are harmonious that they all try and agree on everything and on a daily basis treat each other equally, because that makes for good relations in a business like this where personal relations are essential. But we know the parties have fallen out in a very big way. There are threats. I don't know what's happened to them over a 994 petition. He's been removed as a director. His solicitors have made allegations against your clients. Your solicitors have made allegations against him. The parties are no longer in a harmonious relationship. So he has no incentive. Neither side has any incentive to be cooperative with each other. Whereas for 20 years they did have a very powerful incentive to be cooperative with each other. And so I wonder whether the mere fact that they did cooperate and treat each other equally and fairly and harmoniously for 20 years really does tell you anything very much about their legal rights when they fall out, which they undoubtedly have done. And it is said against your case that what it comes to is that he's owed over £2 million, which is not disputed, but will never in practice have any right to it at all, because your clients can always say, we don't want to make a demand. And they can always say, we're not going to sell the company, we'll continue to run it for the next 50 years. And what is the answer to that, which is said to be a very uncommercial thing, and therefore, in itself, a very unlikely thing to have actually been agreed, as opposed to, well, it's all a good idea to put the profits in and leave them there as long as we can, which is a different thing.
So, my lord, that there are, I think, a couple of different points bound up in that. The first point to make is that I don't suggest that the way in which the arrangements worked over what my lord would say are the 20 harmonious years is necessarily a smoking gun answer to this claim. Like most pieces of evidence in any piece of litigation, it is susceptible to more than one explanation. And it will be a matter of judging at trial, if we get there, following cross-examination, to decide whether, in fact, it truly is supportive of my case or not. But on a summary judgment application, quite wrong to discount it as being an entirely neutral factor. So that deals with my lord's first point. My lord's second point is the uncommerciality of the situation. And can I respond in this way? The first point to make about it is that no doubt what these parties didn't do was contemplate a situation where they were at each other's throats 20 years later. So it's not surprising, if indeed it is an uncommercial arrangement, which I don't accept, but I'll come back to that. It's not surprising that what they might have done is to reach an agreement which had a rather harsh effect in a particular factual scenario that they didn't contemplate. And there's been no suggestion in this case of, for example, an implied term which was designed to fill a gap in the agreement, to deal with an uncontemplated situation or anything of that kind. They thought, one would assume, that they would go on to make very substantial profits and they would grow exponentially by reinvestment, and then they would decide at some future date together that it was time to get out and take those profits with them. So the fact that there might be uncommerciality, which I don't accept, doesn't tell you anything about what they in fact agreed 20 years earlier. But then let me come on to the second point, which is the issue of uncommerciality. It's not the case that there can be a lockup of the claimant so that he's never able to get out his money, because the application of the unanimity principle works so that if the directors decided that they were going to try and disadvantage the claimant, they'd be simultaneously disadvantaging themselves. It's not dissimilar to a shareholder situation where everybody
Can
holds
you
the same.
explain that? Claimant says, I'm fed up with this business, I want out.
Yes.
And the defendant say, well, the two other directors say, well, we want to carry it on. So you can't have your money.
Yes, but if
How
they
does that
want,
disadvantage them?
but if they want to take their money, then they have to pay him his money, because that's
Yes,
the way
why-
in which.
But they can say, well, we're not going to take our loans back. We will have a salary as employees of the company, as directors. That's nothing to do with loans. That's directors' fees.
Yes, my lord. It's not for me to try and make out the claimant's case for him, but I can well see circumstances where it might be said that this was an agreement which provided for a discretion, and that was a discretion which had to be exercised reasonably. And if in fact what the other directors were seeking to do was in effect cheat him of his money by taking their remuneration out by way of director's salary, then you can see how that might be subject to challenge. That there may be lots of circumstances in which this situation was controlled either by fetters on discretion or by implied terms, but none of that is presently a feature of this litigation, and the judge was unattracted by the uncommerciality point. He wasn't with the claimant on that, and there has been no respondent's notice to advance that point on this appeal. But I don't accept it works uncommercially, because in ordinary circumstances, the arrangements continue, the regular monthly payments come out, the directors are bound to treat the claimant in a way that is equivalent to the way in which they treat themselves. And so he gets his money out. It just happens over time rather than in one slug. And you have to balance that against the uncommerciality of an alternative situation, because one must remember that the reason why these arrangements were arrived at in the first place was because the intention was that rather than taking profits, they would all go back into a company that was engaged in property investment. It means that what the company would never have were profits washing around. My lords and my lady have seen, I think, from the 2021 accounts that the sort of sum of profits invested at that stage was about £10 million or just a little less. So if in fact it's right that what the claimant was able to do is make a demand for immediate payment, that would be for a sum of, let's say, 3 million, which the company would never have. It would have it in assets, but it would never have it in ready cash. What could be less commercial than giving rise to a situation where at any moment, on the whim of a single director, the company would be rendered insolvent? So there are powerful balancing arguments to the suggestion that this was uncommercial.
Yeah.
Was the decision to reduce the drawings to nil a unanimous decision?
I'd have to take instructions on that, my lord. I don't know.
It seems unlikely because the claimant complains about it. He says, you've stopped my monthly payments. He's currently, as I understand it, getting no money out of this company, of which he is a third owner, at all. You say, well, the other directors aren't taking any money out either. Mr. Usmani's evidence is reductions in monthly payments require unanimous agreement. And that is the thrust of your submissions. There's nothing uncommercial about having unanimity. Now, maybe that it doesn't affect the questions you've made submissions to us on, or the disposal of this appeal, but it does seem slightly unattractive. They can not only remove him as director, but if this is the case, without his consent, say you were getting quite a reasonable income from this company and now you're not going to get anything.
Well, my lord, just without taking instructions on that point, there's a ready answer to that, which is that if in fact the reduction is challengeable because there's no unanimity, then what Mr. Malik has is a claim open to him. It's not the one he makes in this claim.
That I have understood very clearly.
But one can well see, my lord, why in the present circumstances of the commercial property market, there may be significant stress in terms of the cash flow of companies in this area. And it might be said, I don't know, that this was an emergency situation where directors acting in the best interests of the business have decided to do something which might well be a breach of contract, but nonetheless
I don't understand, I'm afraid. What would Mr. Malik's claim be? There's no agreement that he would be paid anything.
Well,
your case is there was a negative agreement that he would be paid nothing unless there was unanimous agreement.
Yes, I think I'm not suggesting he does have a claim. What I'm pointing out is that what he might choose to say is that if there was a moment in time where, say, that the agreed monthly drawing amount was £10,000 and that was then changed without his consent, he would say, well, the company is not entitled to do that because it would require the unanimity of the directors to reduce that £10,000 to £2,000 or zero.
And who would he be suing? The company or the directors?
It seems to me he'd sue all of them, but ultimately he would say that his agreement was with the directors and they were the ones who'd acted in breach of his agreement with them. It comes back to the point my lord made at the beginning.
Well,
but
I'm a bit lost with how the company gets to rely on this agreement at all.
Well, Lord, I said at the outset that if that point had ever been taken against us, then logically what we would have done was join the directors. No doubt the directors would have wanted to be joined because they would have wanted to assert their agreement against Mr. Malik to prevent him from bringing the claim that he does against the company. And that would be a relatively straightforward way.
Wouldn't that be for them to bring a counterclaim?
Yes, but they would only...
Mr. Malik says, I lent money to this company and I want it back. And if you were to say, no, you can't have it back because you agreed with the other directors or the other shareholders or whoever it is, or just your brother and brother-in-law, and we, as individuals, can stop you because you agreed with us that you wouldn't ask for your money back, isn't it for them to bring a counterclaim? Why should Mr. Malik have to join them?
Well, he doesn't... I'm not suggesting he has to join them, my lord, but what he has to do is take the point. So in other words, what he would have to do in his reply, at the very least, is say, well, okay, let's assume for a moment that I'm wrong and there is an agreement in those terms. The company can't rely upon it because it's with the directors, at which point, self-evidently, there would have been joinder of the directors, which disposes of the point. So it may be, if my lords and my lady are with me and this matter goes any further, that Mr. Malik decides it's not a point worth taking because it doesn't get him anywhere. It just involves technical joinder of the directors.
Thank you.
Right, so we're on to time to pay.
Time to pay. And I'll try and deal with this relatively quickly, not least because it seems to me, and I accept, that it is inevitably a quick and dirty exercise which a judge has to perform. You know, it's not finger in the wind, but nonetheless, I accept that they are difficult conclusions and the judge has to do the best that he or she can based on the available evidence. But what I do say about this case is that the circumstances were particularly clear because what one has is a situation where there is not enough cash to pay. And nobody would expect the position to be otherwise because the very business model of the company is not to have cash but to reinvest it. There is a strongly positive asset position. I'll make these points good in a moment on the documents. But the assets are not, not gold bars. They can't be sold the next day. They're encumbered commercial properties, often with tenants. And inevitably, there is a process for marketing and sale which takes time. And insofar as they can be sold at all in a short time, that has an effect on value because it's a fire sale.
Why can't they be mortgaged?
Well, Lord, the evidence was that we've got, I'll show you in a moment what the mortgage amounts were against the properties, but they were at the top end already of what mortgages could be obtained. So if there was going to be money coming in, this would have to be by sale. And sale was something that would take some time. Can I just start before taking you to the documents by looking only at one authority, which is Lewison and Stack. And that's in the authorities bundle at tab 6.
6, did you say?
6 in mine, yes.
Yes.
And I need take you to only one passage. And it's 23 on page 127. If I could invite my lords and my lady, please, to read that.
Yes.
And I draw only one proposition from that passage, which is it's not a test of exceptionality. It just requires a basic consideration of the facts in any particular case. And self-evidently, if there is a situation where by providing time to pay, one can increase the chances of achieving successful payment and at the same time decrease the damage done to the paying party, well, then all the stars are aligned. And that's an ideal case in which to make an order of this kind. Now, the cash position of the company is dealt with at page 186 of the supplemental bundle.
What was the date of the application before the judge?
The application before the judge was the 11th of November 2022. And so what one has here at 186 is the projected cash flow for the 6-month period, a 5-month period, I should say, going forward. And my lords and my lady will see that the cash flow turns, or the cash position of the company turns quite strongly negative by March 2023. And that's because investment funds come in from the sale of Solomon Passage. You see that one column from the left, about halfway down, the figure is 2,820,500.
Yeah.
But there is then an equity requirement for a new project looking down the same column at Ealing Broadway in a sum of 3.4 million.
What does that mean?
Can I do that, please, by reference to the evidence? If my lord turns back to 181, this is the witness statement in support of the application for time to pay.
Yeah.
Paragraph 13 deals with Solomon's Passage. So that explains the
That
2,820,500.
explains the inflow. Yeah, Yeah.
Yeah, and then in terms of outflow, if one goes to 15, paragraph 15 on 182,
Right. Okay. So there's already a contract for Ealing Broadway in place.
no, I don't think I can.
Well, he says contracts have already been exchanged.
Yes, can I just show you what at this point in time, yes. Can I just show you, please, what the evidence was in terms of when that happened? If my lords and my lady go to page 270, we have a third witness statement from Mr. Usmani.
Yeah.
It's paragraph 4C, because the complaint made, I think, is that the contracts for Ealing were exchanged after the claims were articulated by Mr. Malik. And my lords and my lady will see the last
Yeah.
4 lines. It's June 2022 when contracts were exchanged. I just wanted to show the court that. So that's the position in terms of cash. The position in terms of assets is at 187. And what the court has is the asset value loan amount.
Sorry, could you tell me that? Reference?
I'm sorry, it's supplemental 187.
Thank you.
Yes.
And so what the court had in front of it on the consequentials hearing was the asset value of the property owned by the company versus its borrowing.
Mm-hmm.
And one can see that the borrowing is very substantial, albeit that there is significant equity value.
Yeah. Nearly 20 million.
Yes. So what one draws from that is that this is hardly a company which is underwater, indeed quite the contrary. But in terms of its ability to access ready cash, that is limited. What it has to do is sell in order to
I
be
don't
able to.
understand. Why does it have to sell? Well, it's got a lot of unencumbered properties according to this schedule.
My lord, no. When one looks at the borrowing figures, they're for portfolios of property. So if my lord looks, for example, at Henley Homes RF Limited, which is the third entry on the page, although the borrowing figure appears at the bottom,
Well, it's the whole portfolio.
it's a whole portfolio.
All right.
But it still shows that for Dun Alistair Hotel Limited, the hotel's worth 7.5 million, and there's a small additional property in that company. And the borrowing is less than half that, it's 3,375. Are you saying that on a commercial property like that, these are not properties in the process of development, these are completed investment properties, as I understand it?
Yes, I believe so.
That on a commercial property like that, you can't raise more than 3.375 on a portfolio worth 7.6. Is that the evidence?
Yes, the suggestion is that there cannot be. The witness statement was provided in support of this application deals with some of these assets quite carefully. If one goes to page 182, there's, I mean, this is really a witness statement which pays being read in its entirety, but from 16 onwards, there is an account of a project in which the company is presently engaged in respect of 2 hotels, and for which it will need funds to be able to complete without very damaging consequences. We then go to paragraph 21, which is the borrowing against Havelock Terrace. 22 are corporate guarantees for 46 million. 23, the proposal is to sell, but a forced asset sale, third line, will destroy the group's carefully planned and balanced business plan. Paragraph 25, investors are reluctant to commit significant purchases. Any orderly sale of any of the group's assets, other than the pending sales described above, is likely to take at least 6 months. So that was the evidence that was given in support of the application. Then there was the supplemental, the responsive witness statement, which is Usmani 3, and that's page 270 of this bundle. And that deals with a number of responsive points that were made. What I can't do is suggest to you that this evidence dealt with specifically the ability to obtain further borrowing against any particular property.
It seems very odd that a company which has got 20 million plus of assets over liabilities, according to the asset schedule, cannot borrow just under £3 million.
Well, my lord, the difficulty is that a bank wouldn't look at it in that way. They'd look at a particular portfolio of property and would apply their own rules.
They might take a debenture, they might do all sorts of things. But it just seems very odd. You've got £20 million surplus and you can't borrow 3.
Well, it's not a particularly easy market, and there is significant borrowing against these properties. So it is difficult to conclude that there would in fact be a basis upon which more money could be borrowed in these circumstances. And even then, rates of borrowing would be extremely substantial. If adequate time is given, there can be sale. And if there is sale, then money can be realised to pay without undue consequences to the company. And of course, it is a company in which Mr. Malik himself has a 1/3 interest.
Yeah.
Well, the only additional point I've been going to make is that, albeit not in the witness statements for the hearing in front of the judge, there was a witness statement filed for the stay application in this court, and that's at page 24 of the core bundle. And at paragraph 32 of that statement, you have the evidence there about borrowing. They were up-to-date loan-to-value ratios. These are at the maximum levels that it is sensible to borrow, and there is simply not the capacity to borrow further funds at this time. So that is what Mr. Usmani says, and I suggest there's no basis to go behind that. Plainly, if one had a ratio of borrowing that was extremely small, one might look at that with a sceptical eye, but that's not the position here. There's already very substantial borrowing against these properties. Lords, my lady, there is one final point I was going to make about the time to pay application, and it's this. The judge does not seem to have been attracted by it, But the night before the consequentials hearing, at about 5:30 p.m, a witness statement was served by Mr. Malik, which suggested that the day after the draft judgment was circulated, the directors had acted in a way that was designed to try and frustrate payment by effectively taking £3.6 million out of the company by virtue of a charge. It was an allegation which we had no time to answer on evidence. I dealt with it in front of the judge by explaining it was wholly wrong. I don't know if that allegation is going to be made again in front of you. If it is, perhaps I'll respond by way of reply.
Yeah.
But there is nothing in it whatsoever. You have an accurate account of what cash this company has and what assets this company has. I'll just take some instructions, Malik. Lord, my lady, unless I can assist you any further.
I had one other question, which is Mr. Tarakuzmani's second witness statement at page 181, supplemental bundle. Paragraph 14 has a very brief statement that the sale of some of the group's ground rent portfolio is currently being explored. Is that something that we have any more evidence on, what that portfolio consists of, what it's worth? I don't think, unless I've misunderstood it, it's included in the schedule of investment and development properties, or 187.
No, I don't believe it is. Can I just take some instructions? It's not been sold yet. The expected value of it is likely to be no more than the loans secured against it.
Thank you.
Thank you very much, Mr. Green. Yes, Mr. Solomon.
My lords, my lady, this case concerns loans. The respondent, my client, says that no repayment terms were agreed. You've seen that clearly set out in the witness statements. The appellant, on the other hand, says that complex terms were agreed in which there had to be unanimity for repayment, or what they call in the pleading a liquidity event. On the respondent's case, my client's case, if he's correct, as a matter of law, the loans are repayable immediately or on demand. It's made a demand if they haven't been repaid. For the appellant to succeed at trial, it has to prove that repayment terms were agreed as they're alleged, and the loans were made repayable according to those terms. But the key point, as I understand it, in the appellant's case, is that because this is a dispute about what the appellant says were oral terms, it's got to go to trial. That's a dispute of fact, and that must therefore go to trial. And we say that's wrong. It is not a point of law that every dispute of fact must go to trial. On the contrary, the case law says that judges shouldn't take at face value every assertion that a respondent to a summary judgment application makes, however fanciful. In this case, we make and made before the judge, and the judge understood that we made, three key points. First, there was not a single document supporting the appellant's case. And in fact, its case is contradicted by the documents and is internally inconsistent. Secondly, the appellant's own evidence doesn't advance its case, and indeed, in places, contradicts it. Third, all the relevant information
was already before the judge. The appellant had completed, the parties had completed initial disclosure in which there was nothing supportive of the appellant's case. And the appellant had relied on 3 witness statements. And furthermore, the appellant's own case was that there was nothing in writing on the agreement, but it would be evidenced by facts subsequent to the agreement, which it had. It had all the relevant documents. And that point is recorded by the judge in his judgment, paragraph 2, page 104 of the court bundle, when the judge sets out the important letter of the 11th of January 2022 from the appellant's solicitors. You'll note it's in the supplemental bundle at page 257 to 8, but there's no need to turn to it because it's recorded at length in the judgment. And halfway down the big paragraph of that letter, in between the 2 hole punches, the letter describes how the shareholders have drawn their loans to cover expenses through monthly drawings, subject to agreement of all 3 one-off items providing cash flow committed. Then it carries on, there is nothing in writing on this, but it's evidenced and represented by the actuality of how the 3 have accessed these loans. So that's their own case. So, against that background, we say the judge was entitled, in fact right, to grant summary judgment on the way in which the case was put before it. So if I may, I'll adopt the same approach that my learned friend adopted, which is to look at the judgment and then I will go on to address my learned friend's grounds. What I will do is hopefully advance a position which shows why the judge got it right, and then deal with the grounds swiftly because I will have covered the groundwork already. So the appellant's case is that there was an oral agreement in place for over 20 years, albeit that there is not a single document recording that, and its own records appear to contradict it, and that the first time there was any mention by anyone of this agreement was when demand by my client for repayment was made. We say that's a frivolous position, ripe for summary disposal. The approach that was taken below was that the accounts were a good place to start to see what liabilities the appellant company had. And as the judge accepted in paragraph 7 of the judgment, McCarthy and Tan is authority for the proposition that the audited accounts of the company are primary documents which may be relied on to provide an objective account of its financial affairs. McCarthy and Tan's in the authorities bundle, but there's no need for me to take your lordship, my lady, to it because it doesn't go any further than that point. The respondent below disputed that McCarthy and Tan was applicable, it said, because it's a very different case on facts. And you can see the way in which it was put by Mr. Campbell.
Can we call them Mr. Malik and the company, because respondent below, appellant here is going to get confusing.
Yes. The company put its case saying McCarthy and Tan is. It's my fault. I probably got the wrong names as well.
No, I was just trying to work out appellant where, respondent where.
Yeah. Can I apologise in advance for getting it wrong next time I refer? the company put its case on the basis that McCarthy and Tan isn't relevant because it's very different facts. You can, Your Lordship, my lady, you can see how the argument went, page 147 of the supplemental bundle. Penultimate paragraph, company barrister said, can I start with the accounts to occupy the centre stage of my learned friend's submissions? My learned friend starts the case of McCarthy and Tan, and he goes on to explain why the facts were different from McCarthy and Tan. And over the page at 148, second paragraph down, company's barrister said, we're in a world away from a position where somehow the accounts have to be taken as false. Judge said each case turns on its own facts. The only relevance of McCarthy and Tan is the statement that the audit accounts are primary documents which may be relied on to provide an objective account. You're going to say yes, but there's a realistic prospect this isn't so. And then
I think Mr. Cohen accepts that. He just says the accounts aren't inconsistent with his case.
Well, I think he says in his skeleton argument they may need to be reconstructed and they may be wrong.
No, I don't think so. I think he says they may need to be supplemented by evidence of when money went into the company and where it came from, or things of that sort. But he says if you just look at the accounts, they are consistent with his case.
I'm reading from my learned friend's skeleton argument.
My point, my lord, about reconstruction is the 83,000 in the 2002 accounts. It may be possible to reconstruct how that sum is made up. That's all.
Perhaps Mr. Cohen could reply rather than interject. I'm reading from paragraph 20 of my learned friend's skeleton argument, where he's not talking about the 83,000. He's talking about the 2001 and 2002 accounts. At the top of and he says, at best, bottom of page 66, paragraph 20, at best, the absence of the record of the loans in 2001 and 2002 accounts would suggest either these accounts were inaccurate or the agreement to make the loans was reached by the founders after the period of these accounts. So either the accounts are wrong or my client's account is wrong. But the position that was adopted below was that the accounts were right. And Mr. Campbell, counsel for the company, said in the middle of the page, what I say, even more than that, my lord, is that the published accounts in this case are consistent with my case.
Yeah.
So the judge understood the point that the published accounts provide an objective account, primary documents which may be relied on to provide an objective account of what's going on. And we say that's right, and that derives from the statutory duties in the Companies Act to have accurate accounts.
Yes.
The point that I drew to the court's attention in my learned friend's skeleton argument was not made below, that the accounts might be wrong or that the appellant's position might be wrong. Neither point was made below. We said it's simply not open to Mr. Cohen to make these submissions now. So turning to the accounts, if I may. The accounts have consistently said, since the loans have been recorded, that they were due within 1 year, repayable within 1 year, and owed to the directors. Your lordships have been taken to the supplemental bundle, page 239. Which records in the year ended 2021 the debt directors and a few pages earlier, page 233, which records creditors, amounts falling due within 1 year, and it's presumed that the director's loans are included within other creditors in note 22.
Yeah.
And my Lord Justice Nugee correctly pointed out that the way in which this is accounted for, related party transactions, does not appear in the 2002 accounts. So there is no record of that in the 2002 accounts, and that's an important point, hidden in a footnote in our skeleton argument. And that the director's loans were repayable within a year is also how Mr. Lala explains in his evidence what was going on. So Mr. Lala, the company CFO, Chief Financial Officer, says in his paragraph 43 and 44, pages 72 to 73 of the supplemental bundle, that the loans were recorded as due within 1 year. This is how they've always been recorded since I joined the defendant. He joined in January 2013. The question of whether they are properly due within 1 year has never been raised by me or the auditors, nor by Tariq Chief or the claimant part of this dispute. As mentioned above, the loan account was referred to internally as director's loan account, similar description, because that is how the claimant, Tariq and Kashif, were referred to as distinct from other staff members. I'll come back to that because the judge refers to that in his judgment paragraph 10. The loans were therefore also referred to as money owed to the directors in note 28. So he confirms that throughout the period that he's been CFO, from 2013 onwards, they've always been recorded as repayable within a year and always were directors' loans. And this is inconsistent with the company's case, as the judge found at paragraph 10, because they are recorded as directors, paragraph 10, page 106 of the call bundle, because they are recorded as directors' loans and were repayable in 1 year without any mention of a liquidity event or unanimity. So if I may turn to the question of the categorisation of the loans. This is dismissed by my learned friend, or at least it was in the written argument before this court, as a non-issue. It simply doesn't matter. Although my learned friend in his oral submissions did come back and say, actually, they are properly to be categorised as shareholder loans. So the company's position has changed again. If I can briefly show you how this point was put in the various documents. I know your lordships and my ladyship have read the documents, but it's useful to see how it's put, if I may, take you through the pleadings and the witness statements very quickly.
Let us suppose, for argument's sake, it has been put in different ways. Where does that get you?
But it shows that the position advanced before the court by the company was that it's a shareholder loan. And the court said, there's no evidence of that. It doesn't look like a shareholder loan. It looks like director's loan. All the evidence points to director's loan. And the counsel for my client, Mr. Hallban below, said if it's a shareholder loan, they lose. The company loses. They can't succeed if it's a shareholder loan.
Sorry, I don't understand that. Why does it make a difference what you call it? It's money owed to three individuals. Whether they're shareholders or directors, they are in fact both. It doesn't seem to me to make any difference at all to whether the money's owing.
It doesn't make any difference to the terms of the agreement.
So what is the significance of this point? Both parties seem to have thought it was a highly significant point. And I could see that if you were running a case, but I don't think you are, that if it's a director's loan, when you cease to be a director, X hypothesised repayable, then it might be important to decide if it was a director's loan or not. But that's not your case. Your case is a much simpler one, which is it's a loan. Nothing was agreed about when it was repaid, so it's repayable on demand. And I don't understand, and I'm sure it's me, but I don't understand why it matters whether you say this was a loan by somebody qua director or somebody qua shareholder. It's just a loan.
That the point your lordship made just now is our case. At paragraph 7 of the particulars explained, page 123.
Okay.
Sorry, 129.
123.
123.
Yes. That must be where I got it from. The director's loan account was in any event repayable upon the claimant ceasing to be a director.
Yes,
What?
and that's denied by the...
What's that, an implied term? It's not an express term, is it?
No. We say there are no express
You
terms.
say no express term. It must be an implied term.
Presumably, but that's taking a step back, Malik, rather than pleading the case on my feet.
Yeah.
The way in which this case progressed was our particulars of claim advanced the position that the loans were made as directors' loans. So that's obvious from particulars of claim. Paragraph 4 says since 2008, claimants made substantial directors' loans to the defendant, which have been credited to the directors' loan account. And I've shown your lordship paragraph 7, which is it's repayable upon him ceasing to be a director. Now that may be the reason that the company took this point, because if perhaps it considered if it accepts a director's loan, it has to repay it. But the way in which the company put the point is it's not a director's loan, it's a shareholder's loan. And that is made absolutely clear. So the second part of my argument, my lord, the second part of my response to your lordship's question, which is what difference does it make? First, our case is it's repayable because he ceased to be a director. But second, it's a question of fact. So our consistent case has been it's a director's loan. That's what all the documents say. And what the company says consistently is it's not a director's loan, it's what shareholders' loan. We deny it was a director's loan. This was made by the shareholders as shareholders. But that case, A, was contradicted by all the relevant documents, not just relevant documents, and B, was abandoned at the hearing before the judge. And so, was it legitimate for the judge to take into account the fact that the company's case had completely shifted on this? Well, of course it was. I accept, however, that it doesn't make any difference to the terms of any agreement that were reached.
Except insofar as you plead it was repayable when Mr. Malik ceased to be a director.
Yeah. And yes.
And what's the company's answer to that? Assuming the company has said, and I think Mr. Cohen still says, it doesn't matter whether these are directors' loans or shareholders' loans, but you have pleaded that if they were directors' loans, then when Mr. Malik ceased to be a director, his director's loan was repayable. What's the company's answer to that?
Paragraph 13, page 129. Your lordship was ahead of me, but refers to 129. Paragraph 13 says paragraph 7 is denied and refers us back to paragraph 9.
And that says it's the shareholders' loan.
They're not directors' loans, they're shareholders' loans,
Yeah.
and these are the terms of it. So there was an issue between the parties. So the defence, if I can just pause for a moment on the defence, because it's not an insignificant point. The defence denies at paragraph 3 that, I'm starting at 125 of the court by law, that there were directors' loans, I apologise. They would be advanced, it said, to the defendant by way of shareholder loans. 3.2, over the following 2 decades, the shareholders and the defendant consistently proceeded on the basis that the said shareholder loans increased.
Yeah.
And the last line there, save for the period immediately pursuant to a director's loan.
Yeah. Then it
Paragraph
goes on 7.2, advanced as shareholder.
exactly.
Yeah.
8.2. These are 8 and 8.2 shareholder loans.
Yeah. Yeah.
Then the terms of the shareholder loans, paragraph 9, and 10.5 and 10.6.
Yes. Yeah.
Further evidence, and this is signed by a statement of truth.
Yeah.
So this is the factual basis on which the company is resisting it. And this is put in issue in the reply 131, paragraph 2A and B.
Yes.
They weren't shareholder loans, they're director loans. And 5 and 2E, page 132, and paragraph 5B, page 134.
Yes. Would that be a convenient moment, Mr.
Yes,
Simon?
thank you.
2 o'clock.